Good morning. In behalf of the chairman of the Defense Committee, Senator Sonny Trillanes, who is currently out of the country, I, as vice chair, will open this first public hearing on the EDCA. May we ask the ComSec to read the names of the members of the panel present here today to give us the briefing. Just for the record, I will no longer read the letter of Senator Trillanes to this representation. To chair, in the meantime, the executive briefing in his absence, just so that it is clear that he has designated this representation officially. There was also another letter to Senator Trillanes by Senator Santiago that she will hold a separate hearing on foreign relations on another subject, but pertaining to EDCA, mainly on the foreign relations aspect and perhaps the constitutionality of that. This briefing will cover the military and defense aspect and frequently asked questions on the defense arrangements, and may or may not cover those which will be covered in the Foreign Relations Committee, so there is no overlap. We also put the letter of Senator Santiago on the record so that it is clear that there has been such a request. There is a recommendation from the ComSec that the panel be placed under oath. Is there such a need? Why do we need that?
Under Section 12 of the Rules of Inquiry. They have to take vote.
Why only my defense committee? Sa NVI committee, I don't do that.
Inquiries in aid of legislation.
Because it's an inquiry. Okay, you don't mind that we request our guests, before we recognize you officially, to kindly take your oath. Thank you.
May we request everybody to please raise your right hand. Do you swear to tell the truth, the whole truth and nothing but the truth before this inquiry in aid of legislation of the Committee on National Defense? For the record, Madam Chairperson, all our resource persons replied in the affirmative.
Thank you very much. May I also request a ComSec to read the names and the positions just to conserve my voice? Thank you.
Yes, Madam Chairperson, for this morning's public hearing of the Committee on National Defense Security, on resolution number 623, we have invited the members of the EDCA panel, headed by the chairman, Undersecretary Pio Batino of the Department of National Defense, and the following members. We have Yusek Francisco Baraan III from the Department of Justice. We also have ASEC Raymond Jose Quilo, Assistant Secretary for Strategic Assessment, Department of National Defense. Then we have Ambassador Lourdes Iparagire from DFA. And lastly, Ambassador J. Eduardo Malaya, also from the DFA. That's all, Mr. Bram, Chairperson.
Thank you very much, Committee Secretary. Allow me to welcome the presence, to provide quorum, and to engage us in an interesting discussion this morning. Senator Ferdinand Marcos, Jr.
Good morning, Madam Chair.
Recently, the nation bore witness to the signing of the Enhanced Defense Cooperation Agreement between the Philippines and the United States. This is a sole item in the agenda today, pursuant to proposed Senate Resolution 623, authored by the chairman of the Committee on National Defense, Senator Antonio Trillanes IV. The committee has called this hearing in order to be briefed by the members of the EDCA Philippine panel on the contents and coverage of the agreement. We are hoping that the distinguished members here with us today can elaborate for the benefit of the public and our fellow senators how the agreement stands to benefit our country in terms of strengthening the military capability of our armed forces of the Philippines in promoting peace and security in our national territory. Some sectors seek the nullification of the EDCA, claiming that the pact undermines our national sovereignty. That is the reason why we are here to listen, learn, and be clarified. While there is also a controversial issue on whether or not the EDCA requires Senate concurrence, or whether or not the EDCA is a treaty or an executive agreement, we wish to train the focus of the committee on the sense of PS Resolution 623 in seeking to examine the extent of the strategic military relationship between the two countries. The EDCA has brought divergent views from all sides and resolving it would certainly require that the committee receives accurate information and engages in intelligent deliberation. I thank you all for your presence today. I look forward to your valuable inputs. May we hear first from Undersecretary Pio Batino, after which we will hear from the DFA represented by Ambassador Lourdes Iparagire and Ambassador Malaya, and of course the DOJ Undersecretary Baraan, and Asek Kilop was also a member of the panel. Thank you.
Thank you, Madam Senator. Good morning, Honorable Senator Lauren Legarda, Honorable Senator Ferdinand Marcos. In behalf of the Philippine panel, at the outset, allow me to thank you for this opportunity for being able to present the Enhanced Defense Cooperation Agreement, or EDCA, signed between the Philippines and the United States. The EDCA is an agreement aimed at advancing the implementation of Article 2 of the Mutual Defense Treaty, which states that the parties separately and jointly, by self-help and mutual aid, will maintain and develop their individual and collective capacity to resist armed attack. Given the rapidly evolving geopolitical and climatic realities in the Philippines, and the conduct of joint training exercises between the armed forces of the Philippines and the U.S. forces for over more than a decade, the EDCA is a natural progression of the alliance between the Philippines and the United States. But taking the next step certainly required that the Philippines must ensure that our national interests are protected and advanced. In this regard, the Philippine panel mandated by the President to negotiate the agreement strictly observed the following principles: strict compliance with the Philippine Constitution, laws, and jurisprudence, utmost respect for sovereignty, requirement for Philippine consent for all activities, no permanent presence or base by the U.S. troops in the Philippines, full Philippine control over facilities to be used, mutuality of benefits, non-exclusivity of use of the designated areas for U.S. Armed Forces, enhancement of AFP capabilities through joint training exercises, prohibition of nuclear weapons, and U.S. commitment for long-term AFP capability buildup. Honorable Chair and members of the committee, the Philippines faces serious challenges to our sovereignty and sovereign rights. Developments in the region point to increasingly assertive acts. To human safety and security, the frequency and severity of natural disasters point the need to anticipate, address, or mitigate their real impact on our people and communities. The EDCA will support efforts to prepare our nation for these challenges. At this point, allow me to emphasize that the priority of the Philippine defense and military establishments is its own capability development as enshrined in the revised AFP Modernization Act. Through the full support of President Aquino and the Congress, the revised AFP Modernization Program is assured of at least 75 billion pesos for the first 5 years out of a total 15-year period of modernization. We fully appreciate the budgetary support for the AFP Modernization Program, which enables the DND and the AFP to prepare a comprehensive procurement plan of modern defense equipment. Under EDCA, however, we will be able to develop further our mutual defense capability and our interoperability with the U.S. Armed Forces, contributing to the defense capability buildup and the development of AFP bases. By leveraging available resources of our ally, we could develop Philippine defense capacities in the areas of maritime security, maritime domain awareness, and humanitarian assistance and disaster relief, or HADR, through EDCA. In order to achieve these objectives, the EDCA facilitates defense cooperation with the United States by undertaking, number one, construction of infrastructure upgrades, and number two, storage and prepositioning of defense and HADR equipment, supplies, and material. Before these activities take place, it must be emphasized that the prior consent of the Philippine government through the Philippine-U.S. Mutual Defense Board and Security Engagement Board will need to be secured. In addition, these activities will only be done in agreed locations, which will also be determined through the Mutual Defense Board and Security Engagement Board. On construction, kindly allow me to emphasize that constructed buildings and other permanent structures will automatically be owned by the Philippine government. As such, this will greatly hasten the development of Philippine military facilities. On preposition equipment, let me also note that prepositioning will allow us to respond more rapidly in times of natural disaster and other crises. The effectiveness, the Philippine-U.S. alliance, and our military's interoperability was greatly demonstrated in the aftermath of Typhoon Yolanda. Under EDCA, HADR equipment can be prepositioned with agreed locations, reducing the time for disaster response, since these equipment do not have to be brought in from outside the Philippines. With prepositioned equipment and material, our soldiers will be able to train and develop their capabilities even before the Philippine government acquires such equipment, boosting the speed of our capacity building efforts for men and women in uniform. In addition to these benefits, EDCA will further benefit the Philippines economically through the provision of jobs and other economic opportunities in the construction activities in the agreed locations and procurement of local goods and supplies by the U.S. military. It is also worthy to mention that the agreement is very clear, specifying from the beginning in the preamble that the parties' understanding for the U.S. not to establish a permanent military presence or base in the territory of the Philippines. The EDCA does not authorize the establishment of U.S. bases. It only allows the U.S. military access to agreed locations in AFP bases. The defining features of foreign military base, which are extraterritoriality, exclusivity in use, and foreign ownership, will not be applicable in the agreed locations to be established under EDCA. The EDCA is an implementation of the Mutual Defense Treaty, while the status of visiting U.S. forces will still be governed by the Philippine-U.S. Visiting Forces Agreement. The entry of U.S. military troops for military exercises and other approved activities is already allowed under the Philippine-U.S. VFA, which is a treaty concurred in by the Senate and upheld by the Supreme Court. It is our humble opinion that the provisions of EDCA, an executive agreement, are consistent with the Philippine Constitution, laws, and relevant jurisprudence. Honorable Chair and honorable members of the committee, in these very fluid times, we, together, are forced to take a long and hard look at what we can do as one government to respond to the challenges before us. And as we are aware of existing challenges, impediments, and restrictions for our country, we know that opportunities arise, particularly when sovereign interests converge that can mutually benefit common stakeholders. We humbly submit that EDCA is one such agreement that seizes opportunities of the intersection of interests and advances Philippine national interests. Once again, thank you for giving us the opportunity to appear before this committee. We stand ready to answer for your queries, and thank you very much.
Before any questions will be propounded before the panel members, may I ask whether any member of the panel, especially the DOJ representative Undersecretary Baraan or the DFA representatives present here today, would want to make additional opening statements, or does that speak for the whole panel?
That speaks for the whole panel.
Madam.
Thank you. May I just put on record the Philippine-U.S. security agreements to date and kindly update or clarify if this is accurate or complete? These are the following existing security agreements between the Philippines and the United States: the Mutual Defense Treaty of 1951, the Mutual Defense Assistance Agreement of 1953, revised and extended the 1947 Military Assistance Agreement, which constituted the continued commitment of the U.S. to make equipment, materials, devices, and other assistance available to the Philippines. The VFA of 1999 regulates the circumstances and conditions under which U.S. forces may visit the Philippines for bilateral military exercises, and the Mutual Logistics Support Agreement, a facilitation agreement for reciprocal provisions of logistics between the armed forces of the Philippines and the U.S. forces, especially for the limited basing of U.S. forces in the Philippines. Is this accurate that these are the 4 Philippine-U.S. security agreements to date, or is there anything that has been added or deleted or outdated among this list? Just for clarification. Thank you.
Madam, the 4 agreements that you mentioned are the basic agreements between the Philippine and U.S. militaries.
Would we consider the EDCA, the Enhanced Defense Cooperation Agreement, as a 5th agreement?
Yes, Madam Senator, it is our opinion that EDCA implements the Mutual Defense Treaty and the Visiting Forces Agreement, and it stands to be an implementing agreement of the previous 2.
Having read and understood the EDCA, on its face, it seems like it contains policies and guidelines, but does not specify detailed implementation of the agreement. It is understood by this representation that it will be the Mutual Defense Board who will designate the agreed locations, considering that the EDCA had given a blanket authority on all locations in the Philippines. If that is, my understanding is correct, it will be the Mutual Defense Board who will select the areas, whether it is in Philippine bases in different parts of the country. And therefore, much responsibility for the implementation of this agreement will rely on the members and the chairman of the Mutual Defense Board. Is that accurate?
Yes, Madam and Senator, and probably it's also timely to quote the provision that speaks about the determination of the agreed locations, particularly Article 2, Section 4, which provides that agreed locations means facilities and areas that are provided by the government of the Philippines through the AFP. So it is the AFP which has primary determination of which of its bases would be offered for an agreed location for the implementation of activities under EDCA.
May we clarify if these are existing AFP bases in all island groups around the country, or does this also include the previous U.S. bases already turned over to the Philippines, or does it also include places which are not considered existing Philippine bases and previous U.S. bases?
Yeah, Madam Chairman, if I might just expand on
Yes,
that
Senator
question.
Marcos.
On the agreed locations, is that merely existing military bases or military facilities can be an agreed location, or just about anywhere, so long as the mutual the MDB decides that it is going to be an agreed location? Could it be anywhere, or does it have to be existing Philippine base or military installation? Mm-hmm. In other words, can they walk into a town and say that we want to put up a building here and a communications the communications monitoring in any place, or does it have to be inside an existing base or military facility, AFP, military facility?
Clarification.
Thank you, honorable senators. Firstly, allow us to emphasize that this process of determining the agreed locations will still be undertaken in the future. But we also the understanding is that the AFP will take the lead role in the determination of which of its AFP bases would be the agreed locations.
It's so AFP bases.
The direction of the DND and the AFP
Is it possible for the DND to open a new base and then for that to be actually used by the Americans? Halimbawa, sabihin natin, the Americans had asked to put up a base somewhere where there is no, let's say, just for as a any let's say Tacloban, to say to assist in the humanitarian the assistance that has happened that we have to in that area. Now there is no base there, but the AFP then decide, say, okay, we would like to now establish a military base, and subsequently say that is now an agreed location where the Americans can preposition their equipment and material.
The requisite, at least on the part of the Philippine panel, is that AFP must previously establish a presence before any agreed location before that location could be an option.
Okay, so they establish a presence in some town and say, okay, we have an established presence here, we have it for 3 months. Now can it be an agreed location?
If the AFP determines it to be a strategic agreed location for the implementation of activities under EDCA.
And under that determination, it does not preclude any part of the Philippines. They can do this to any part of the Philippines. The AFP can decide any part of the Philippines is now a new Philippine base, at which point it then can then become an agreed location. Would that be possible?
Yes,
under the EDCA?
Yes, Senator. And it is possible, but allow us also to explain that under the provisions of EDCA, this will have to go through the MDB-SEB process, which is the existing bilateral security mechanism, wherein the AFP studies possibilities for joint training exercises with the U.S. So we envision, or we expect, that it won't be that automatic. There will be a long series of consultations before an agreed installation could be determined.
Do we have the procedure for that? For example, how is there a condition where we are said that this has to have existed for 1 year, 5 years, 10 years before it can be a part of one of the possible or potential agreed locations? Or again, to return to my hypothetical, could the AFP designate an area as a new military facility, have the facility, develop those facilities over a period of months, and then subsequently say, this is now one of the agreed locations. We have assessed that this is a strategic area, and the Americans agree, and then they will come in. And is that possible?
We also would be mindful of the processes before any public land could be declared a military reservation.
Well, yes, we have those. We have those procedures already available to the AFP. But having gone through those procedures and having established a new area, new base, new facility, anywhere in the country, can they then make it an agreed location?
Provided that the AFP, Mr. Senator, decides that it is strategic for mutual interests for the conduct of training activities, and also provided, of course, that the processes for the determination of a military reservation is complied with. And may we just reiterate that the EDCA provides that the agreed locations will be provided through the AFP, and therefore AFP presence is necessary before any U.S. visiting forces could be allowed to enter such area.
It says in Article 2, Section 4, that the agreed locations must be appended in this agreement. Can you kindly read the agreed locations in the annex of this agreement, if any? It says that such agreed locations may be listed in an annex appended to this agreement. May. That's why I want to know whether the negotiating panel had already listed the agreed locations so that it is limited to those agreed on by the panel.
Madam Senator, we have not yet started the negotiations or the discussions on the agreed locations. EDCA is primarily a framework agreement to provide the parameters under which the activities would be implemented in the agreed locations to be determined in the future.
My first question was, which was supported by Senator Marcos, which you already answered, regarding the agreed locations to be first, existing AFP bases, and second, previously occupied U.S. bases turned over to the Philippine government, and third, those not covered by both. Subic and Clark, for example, have been turned over after we did not renew the bases agreement. Is it a possibility that both Subic and Clark can be utilized once again by the U.S. forces under the EDCA?
Maybe at this point also, Madam Senator, we also would want to explain the direction of the Department of National Defense and the Armed Forces of the Philippines, that in determining an agreed location or an AFP base, we are not going to make accessible the whole AFP base for the U.S. forces. The process would be that there will be a delineation of the area that would be shared with the U.S. forces, a specific area in the agreed location, a specific area in the AFP base, which would be the agreed location. So there have been speculations that the whole AFP base would be the accessible area for the U.S. forces. With respect to Subic, Your Honor, may we emphasize that the AFP has been requesting for presence in the Subic area, at least limited portions of the Subic area, for the AFP to be able to have their existing equipment, existing vessels, existing planes, and also the modern defense equipment that it will be procuring later on. This is in line with the national defense strategy of prioritizing the West Philippine Sea as a key area for defense and security. If that will be, push through.
Whose decision will it be?
Currently, the Armed Forces of the Philippines is discussing with Subic Bay Metropolitan Authority for the possible transfer or of some of its equipment to limited portions of areas in SBMA.
Once SBMA agrees to the AFP for the partial utilization of its property, then it will be available as one of the agreed locations. assuming it will be requested by the U.S. Armed Forces. But presently, there is no part of Subic that is accessible or utilized by the AFP, and therefore it is not part of the agreed location.
Yes,
But
Madam.
if SBMA says no, AFP, you cannot and you will not, then it is not part of the agreed location that can be utilized by the U.S. under the EDCA.
May I just state that the negotiations are still ongoing. There have been some discussions with SBMA, some general consensus. However, the details on the MOA are still being discussed. So as of now, Your Honor, in line with the direction of the Department of National Defense, Subic is not yet an option for an agreed location.
Is
in
it
this.
being eyed as an option?
The study is still ongoing, Madam Senator. We still do not have any certain. We still do not have any certain locations, although as we have mentioned before in media, that Fort Magsaysay is being studied as a possible HADR focused AFP base for EDCA.
What is HADR?
Humanitarian Assistance and Disaster Relief.
Base for Humanitarian Assistance and Disaster Relief would be Fort Magsaysay in Nueva Ecija.
It is still being studied, very tentative. We still have to undertake studies on which areas, if any, could be shared under this EDCA. It still has to go through a process. May I say that it's just very, the plans are just initial, just in its initial stages.
Apart from the initial stages of the discussions regarding Subic and Fort Magsaysay, what are the other areas being explored for locations?
Madam Senator, Fort Magsaysay and Fort Magsaysay is just really in its initial stages. Aside from that, there are no other.
Subic is not initial.
There's still no
No
discussions
discussion on Subic.
Opo.
I thought that the MOA was already being studied.
For AFP. For
For
AFP,
AFP, not for the U.S.
Yes,
But for
yes.
Fort Magsaysay, the EDCA is studying it for the U.S., but still initial stages.
Yes.
And
yes,
apart from
Madam.
those two, from that one place, Fort Magsaysay, there is no other location being studied yet.
Yes, Madam. The negotiating panel prioritized the execution of the EDCA before any details could be discussed with the U.S.
Madam Chairman, if I could pursue the point on Subic. As it is now, Subic is not what used to be the Subic base, is not of AFP military installation. Am I correct in assuming that?
Yes.
So if that should become, because Subic and Clark are obviously the natural, because the Americans know exactly what they're getting. They've had the long history there, so it would seem natural that they would want to take advantage of the facilities that they had left there. So in that case, now let us say Subic or Clark are similarly situated. How would that happen? Now that they are not military installations, the AFP, assuming the SBMA gives the permission or agrees to allowing part of the existing facility to be used as an AFP military installation, could that then? This is the same question, really, that I'm saying, but now applied specifically to Subic. Could that then be designated as an agreed location, and that process could end up as having Subic or parts of it as an agreed location for the EDCA implementation?
Precisely, Honorable Senator, that these are the circumstances that we have to contend with in discussing possible location of AFP troops and equipment in Subic, because as you've mentioned, the existing law governing Subic would provide that the whole of Subic should be focused on economic and commercial activities.
That's right. Yes, that's precisely the point. But again, it brings us back to the process by which an agreed location is agreed upon, and the fundamental question I think behind all this is, where are they allowed to set up shop? Saan ba sila pwedeng maglagay ng kanilang base? Which is essentially, well, not their base, their, I don't know what you call it, center, headquarters. From what I'm hearing is that mukhang kahit saan sa buong Pilipinas, pwede silang maglagay ng kanilang prepositioning, ng kanilang communications, equipment, etc., etc. Am I correct in saying that it is actually possible for any part of the Philippines to become an agreed location from what we have heard from you this morning?
Sir, the direction of the department and the Armed Forces of the Philippines is to limit the agreed locations to a few.
Is it in the EDCA agreement, the limitations?
No, Your Honor.
There are no limitations in the EDCA agreement.
Yes.
Well, we can only go by what was actually signed by both governments. So in the EDCA agreement, there are no limitations as to agreed locations. So an agreed location could be anywhere in the Philippines.
Subject to agreement.
Subject to
Yes,
agreement, of
yes.
course.
Mutual
Yes.
agreement.
Subject to mutual
So
agreement. I think it's more the more critical determination will be made by the AFP. That is really the end, in my view, that's really going to
That's
be...
true.
They are going to be the actual arbiter.
And the role of the Mutual Defense Board is so important because they are the ones who will implement these guidelines and these policies. I am certain that they will not allow, for example, the setting up of installations in wetlands, in protected areas, in vulnerable areas, in geohazard areas, in multi-hazard and risk areas, in highly populated areas. It would again be logical to set up partial installations and facilities in AFP occupied areas, which are their bases, like Fort Magsaysay, for example, and not bases, for example, that have been converted already into commercial use. It makes common sense that
I was just trying to get the limits of the EDCA, and it would seem to me that there are nothing in the agreement, as I'm reading it now, precludes any area, even the environmentally sensitive areas that the Madam Chairman has mentioned. Then none of that has been.
there is. Can you?
As to the agreed locations.
Can you read that provision, please, on the environment? I understand during the briefing you gave me, there was a provision on protection of the environment. Can you kindly put it on record?
It is in the Article 9, I believe, is specifically directed at environment, human health, and safety. But I think we should ask the USEC to be the one to take us through it.
Can you please put it on record?
Article 9 provides the provisions on environmental protection. The last sentence of paragraph 1 mentions, to this end, the party shall cooperate to ensure problems that may arise are dealt with immediately in order to prevent any lasting damage to the environment or endangerment of human health and safety. Secondly, as provided under paragraph 2, the environmental compliance standards applied by United States forces shall reflect, in accordance with its policies, the more protective of United States, Philippine, or applicable international agreement standards. And thirdly, another provision on environmental protection, which is under paragraph 3, provides that the United States forces shall not intentionally release any hazardous materials or hazardous waste owned by it, and if a spill occurs, shall expeditiously take action in order to contain and address environmental contamination resulting from the spill.
Thank you for that. Marcos, apart from that, was the agreed location, whether it could be based outside existing AFP bases. I would like to help you answer that question in number 2. It says the United States confirms its intent to respect relevant Philippine environmental health and safety laws, regulations, and standards in the execution of its policies. May I be confirmed if my interpretation is correct, that because if this statement says that it will respect environmental, health, safety regulations and policies and laws of the Philippine government, that means everything that is considered part of NIPAS, for example, the National Protected Areas Act, everything that is declared as a national park, everything that is declared as a geohazard area, that is a no-build zone. All of these, if they are respected by Filipinos and therefore respected by the AFP will not offer it as an agreed location. Is that correct?
Yes, Madam.
So that answers our question. There should be no agreed location to be offered by the AFP on anything that would be a geohazard, multi-risk, multi-hazard, environmental area, even if assuming the AFP or the U.S. Armed Forces will ask for it, but because it contravenes or contradicts present laws of the Philippines, it will not be offered and agreed upon. Is that correct?
Yes, Madam. And if I may add, based on the principle that the AFP determines the agreed locations, then this already is a limiting mechanism on which agreed locations could be determined. So the concern that that the Philippine territory already became susceptible to U.S. presence can actually be very much controlled by the AFP, as it takes the lead role in determining and limiting the agreed locations for the implementation of activities under EDCA.
Therefore, okay, so it is, well, that's clear enough that in terms of the environmentally sensitive areas that are already recognized by various laws, regulations, rules in the Philippines are precluded from becoming agreed locations. Is that correct? I think that's what you just said. Yes. Yeah.
Yeah, if I may add to what my chairperson has stated, we think that there are enough limits or parameters in the selection of the agreed locations. In Article 2, Section 4, it says that such agreed locations may be listed in an annex. So eventually there would be an annex, but the intention of the panel was to have as few locations as possible. And also it says here that, and may be further described in implementing arrangement.
Ambassador, that brings us very neatly to the next point. How many agreed locations will there be?
Well, those operational details, Mr. Senator, has not been discussed yet. And if there would be such selection, I think that will not be done by the AFP alone. This will have to be approved eventually, of course, by the Secretary of National Defense and probably approved in a cabinet-level meeting. And there would be, I think, enough deliberation to ensure that what we are offering are only those which would promote our national interest. And may I also add that the presence that we are envisioning in the agreed locations would not be permanent presence. What EDCA envisions is temporary, rotating presence. So they may be there for a few weeks, a few months, and though they may have some barracks or training facilities, they need not be there all through the year, because this is the new kind of security arrangement which is being looked at. And when they build infrastructure, let us say they extend the runway, that runway becomes Philippine property upon its construction, and also will be used by the AFP. Because as mentioned by Undersecretary Batino, there is no exclusivity in the use of the infrastructure that the Americans will build with their own money.
So but as it stands now, as it is written, we do not have any guidelines as to what is going to be an agreed location, what can be agreed location. The only thing that we have had is what the chairperson has raised, is that the environmentally sensitive areas are precluded, I think, from the section from Article 9, as we have read it. So given that, aside from the environmentally sensitive areas, nothing has been precluded in the EDCA as signed as a possible agreed location.
If I may, the EDCA also provides for the key mission areas that need to be complied with for the AFP's concerns. And this would be maritime security, maritime domain awareness, and humanitarian assistance and disaster relief. Secondly, the EDCA also underpins the main objective for this agreement, which is for the maintenance and development of individual and collective capacity of the Philippine and U.S. forces in the spirit of the Mutual Defense Treaty. So these parameters, general as they are, would guide the defense and military establishments in choosing which of its bases would be ideal for the implementation of EDCA activities. The EDCA also provides flexibility for the defense and military establishments to determine, based on existing security issues, the agreed locations to be used, and also in further detail, the area to be shared with the U.S., the construction and preposition activities that will have to require the prior consent of the Philippine government.
Okay, I think we've pursued this subject of agreed locations enough.
Before we proceed to your next question, I just want.
No, I was going to. I was going to cede the floor to you.
Okay, thank you. No, I just wanted to clarify
Yeah.
before we move on from the agreed locations, because the chairman of the panel mentioned about the agreed locations, which are important in terms of their strategic nature. You said it in some similar terms. May I know, what do you exactly mean by strategic in nature? Strategic militarily, strategic. Can you kindly explain?
Primarily, Madam Senator, the defense concerns would be the main strategic issues for the determination of the agreed locations. As EDCA is a defense cooperation agreement, we believe that the defense concerns, security concerns, must be prioritized as considerations in determining the agreed locations, as well as the activities that would be implemented under this agreement.
It therefore stands to reason, if that is your interpretation of strategic, it would mean that the agreed locations must be confined within already existing Philippine bases.
Madam Senator, that is the direction of the Department
That
of
should be the
National
direction. That
Defense.
is my understanding.
Yes.
And therefore, the anxiety or fear of having the whole 30 million hectares, am I not accurate, of the Philippine archipelago. Tama ba ako? 30 million ba?
It's about that, yeah.
30 million bang Philippine archipelago?
About that,
yes,
that's
okay.
that's
No, without Benham Rice. but we have Benham Rice thanks to the DNR, right? Which is bigger than Luzon. Okay. So assuming we're 30 million, so the fear, the anxiety that we will open up the whole 30 million hectares of our 7,100 islands to the U.S. forces has no factual basis, because if you are to go by reason and by the policies which are outlined here, that it should be strategic in nature, and since this is a military and defense agreement, it is more practical, even economical, that they hold it, portions of it, in already existing Philippine bases. Is that correct?
Yes, Madam. And to add, that direction would also bring or address issues on possible absence of control in over U.S. forces, because as they will be situated in AFP bases, they will be guests of the AFP and will be subject to the terms and conditions provided under the EDCA.
Well, okay, Madam Chairman, I'm afraid that I beg to differ. Is that as the EDCA, as it is here before us today, there are no limitations, in fact. To now the annexes that that are still being negotiated, we will anxiously await, and of course we will give our panel the chance to make those assessments. But if the determination is maritime safety, maritime security, we are a archipelagic country, and that could mean anywhere in the archipelago, which gives us a irony, because having defined our baselines, it is the United States is one of the countries that do not recognize our baselines and therefore sail freely through our islands. So they are now going to be the ones to defend that maritime security. So it's a bit of an irony, but I'm sure that the panel will be able to resolve it through the annexes. So that's all I have on the agreed locations, Madam Chairman.
Before we depart from the agreed location, since the Mutual Defense Board, along with the hierarchy of the AFP, and according to Ambassador Malaya, high-level cabinet officials will be deciding on the annexes, is it also agreed that perhaps both houses of Congress, the Defense Committee, may be informed every step of the way regarding the preparations or the agreements on the agreed locations?
Madam, maybe we can also
Give a briefing to the defense.
state that at least with the respect to the AFP modernization program, the Department of National Defense actively engages both committees on defense. So in all aspects of its operations and also its policies, the Department of National Defense had in practice consulted the both committees on defense.
Maybe, Madam Chairman, as the annexes are made, they can brief us on it and explain whatever questions the congressmen
Yes, in
have.
fact, they are amenable to that. I even asked them during the private briefing, because clearly this military and defense agreement is part of the AFP modernization program. And as you said, the AFP modernization program is always open, and we are constantly briefed, the chairman and the members of the Defense Committee of both houses of Congress. It therefore stands to reason that the ensuing operationalization of the EDCA through the decisions on the agreed locations of the Mutual Defense Board will be given to both houses of Congress insofar as the defense committees are concerned. And it also is assumed that all relevant laws pertaining to environment and safety hazard areas will be respected as outlined in the agreement. Is my understanding correct?
Yes, Madam
Yes.
Senator.
Thank you. We proceed to the next point. Senator Marcos, any
Yes,
question?
yes, I do. We've just touched upon that the EDCA is characterized as part of the AFP modernization program. How is that going to work? Because I am reading Article 5, Paragraph 3. No, I'm sorry. No, I'm sorry.
While you are thinking and looking at your notes on the other, may I just ask whether the Tubataha, yung utang sa Tubataha, ay nabayaran na ba? At kasama ba yan sa usapan dito? Because it's been pending for more than a year. Since the DFA is here. Because I see the provision on environmental destruction, and you mentioned about being careful with regards to oil spill and accidents. Is the compensation for the destruction of Tubataha reefs already settled regarding the amount and the payment?
Thank you, Madam Chair, Your Honor. I understand from our Office of Legal Affairs, who is knowledgeable on this issue, that negotiations are ongoing on the compensation package. Thank you, Madam Chair.
Did the issue become part of the discussion for EDCA, or was it not?
No, it was
wasn't
not
covered
mentioned at
by
all.
any? Anyway, to return to what I was going to quote again, to start from the beginning. We are told that this is EDCA is part of the AFP modernization process. How exactly does that going to work? Because Article 5, Section Paragraph 3, U.S. shall retain title to all equipment material. In other words, wala ibibigay sa atin. So how does that help our modernization in maybe in training? I can understand, because there will be joint exercises. But in terms of material, there's nothing here that would indicate that that this will help modernize our equipment. Now, I know that in the joint military exercises that we conduct with the Americans, na marami silang iniiwan na equipment pag every time we have but that's maliit lang yun. So where in the EDCA is it specifically state that they will assist us in the modernization process of the AFP?
Thank you, Your Honor, for that question. The EDCA, as mentioned, concentrates on two activities, namely construction and prepositioning of U.S. equipment as consented upon by the Philippine government. In the field of construction, there is a provision here in EDCA that says that infrastructure improvement introduced by the U.S. will, upon construction, be the property of the Philippine government. There is also a provision here that provides for the concept of proportionate use of the agreed locations, and proportionate use for construction, development, and maintenance costs.
How is the term proportionate use defined?
It is understood to mean that the infrastructure to be introduced, the improvements to be introduced, just as Ambassador Malaya had mentioned as an example, the expansion of a runway could redound to the joint use and mutual benefit of the AFP and the U.S. forces. And under the revised AFP modernization program, a major component of the modernization program of the AFP is basis support and development. We are concentrating the procurement for modern defense equipment for the 75 billion pesos allocated for the first 5 years.
Allocated by whom, Yusek?
The revised AFP modernization law.
Okay, pero galing din sa Pilipinas yun.
Opo. And
pero
we are
in terms of equipment, beyond the software training, in terms of hardware, meron ba silang, will there be something that is akin to the FMS like we used to have before? Will there be any kind of agreement as to credits on military sales, things like that? Meron ba tayong agreement sa EDCA at na ganun?
The EDCA prioritizes the development of AFP bases as a component of AFP modernization. The construction or the improvement of our existing AFP facilities would redound greatly to the benefit
Oo
of
nga,
the AFP
pero
modernization.
yung sinasabi ninyo, the buildings, facilities, etc., sila rin naman ang gagamit, hindi tayo eh. So how is it helping the AFP modernization? Because everything they build, they will use, and while they are using it, the AFP cannot use it. So how does that help? There is no time period by which they say 5-7 years it will be turned over to the Philippines. I do not see any condition like that. So again, it is the strengthening of the American military facilities in the Philippines, not really the AFP. So kasi maraming nagsasabi dito, binigyan natin, we have allowed the Americans to come back in, wala namang kapalit. There's no rental, there's no FMS credit, walang kapalit. Sinasabi natin na yung mga itatayo nilang building, yung mga improvement na gagawin, halimbawa ni Ambassador Malaya, na pahahabain o papakapalin yung ating mga runway. Pero sila rin ang gagamit niyan. They put that for themselves. They did not put that up for us. So what is how are they helping in the modernization? Because parang kulang yata eh. We're not getting a good enough deal in my view. Anong kapalit dito sa ating pinigay sa kanila na access doon sa ating bansa? Yes, Ambassador.
Thank you, Your Honor.
Possible compensation. Yeah, furthermore, in Article 5, the end of paragraph 2, the parties or the designated authority shall consult regarding the terms of return of any agreed locations, including possible compensation for improvements. Magbabayad pa tayo. Magbabayad pa tayo doon sa kanilang itinayo. It says so here. Regarding the terms of return of any agreed locations, di babalik ng Amerikano sa atin. But it includes the possible compensation for improvements and constructions. I'm assuming the improvements and constructions are those that were put in by the Americans. So babayaran pa natin ngayon. So parang masyado naman tayong lugi dito sa usapang ito. Yes, Ambassador.
Thank you, Your Honor. If I may answer, Your Honor, your first question, and I'd like to refer to Article 4 of the agreement, paragraph 2, which says the parties share a recognition of the benefits that such prepositioning of defense material and HADR equipment could have for humanitarian assistance and disaster relief. The parties also recognize the value of such prepositioning to the enhancement of their individual and collective defense capabilities. Mr. Honor, Your Honor, it's the concept of shared and joint use of infrastructure upgrades as well as the preposition material is introduced in this agreement. It can help accelerate the AFP modernization program because the program can begin, even before we're able to purchase the necessary defense systems. Maritime security, which Undersecretary Batino has mentioned earlier, and maritime domain awareness can be given a boost even before we have the ships and the aircraft that the Philippines needs. And also, even before the Philippines has the advanced hardware it wishes for.
How do we get that boost, Madam Ambassador? You say that it will be a boost to our capabilities. In what sense is that going to happen?
One way, Your Honor, if I may, even before we have this advanced hardware, even before we're able to purchase these defense systems, our AFP will already know how to operate and to maintain them. So there is this possibility that the shared use and joint use of preposition material could help accelerate the AFP modernization programs. Also, Your Honor, during the negotiations, we discussed the importance. During the negotiations of the EDCA, we discussed the importance of this agreement in terms of the Pentagon, the U.S. Department of Defense, being able to access more funds to implement our defense cooperation programs. For example, under the Visiting Forces Agreement, or the VFA, the Pentagon can only access ERCs, or exercise-related construction funds, and there is a ceiling of $2 million. Now, here in this agreement, there's a possibility that that's why they need this agreement as well, for the Pentagon to be able to access military construction funds. And it could start from $50 million to even higher than that amount. Thank you.
My understanding is that they've actually appropriated already $40+ million for this. But again, to come back to the idea of the AFP modernization and how the EDCA will assist in that regard. Again, to this concept, ito kasi ang lagi napapag-usapan, wala tayong kapalit. Nung dati, nung Subic at saka Clark, may kapalit. Marami tayong kapalit. In terms of equipment, in terms of training, in fact, in terms of rental. But now, we even have in Article 4, Paragraph 3, the first sentence reads, the prepositioned material of the United States forces shall be for the exclusive use of United States forces, and full title to all such equipment, supplies, and material remains with the United States. United States forces shall have control over the access to and disposition of such preposition material, and shall have the unencumbered right to remove any preposition material at any time from the territory of the Philippines. In other words, silang may-ari, sila lang ang gagamit. So how does this help? How does this help the AFP modernization? Parang hindi tayo kasama doon sa, although maybe they can conduct training, they will show us their latest radar, they will show us their latest communications equipment, but we will not have access to it because it is exclusively for the use of the United States forces.
Yes, Mr. Senator, the paragraph that you mentioned recognizes ownership by the U.S. over their equipment, and this is, I think, a reasonable provision. However, it should also be read in light of the paragraph mentioned by Ambassador Iparraguirre, that the parties share a recognition of the benefits that such prepositioning could have for HADR. And
I think on the HADR aspect of it, we have there is no question. Yeah? Just our experience from Yolanda. If the George Washington did not have to sail from where it was stationed, we would have had the American help earlier by probably a factor of about almost a week. So certainly prepositioning for possible disaster relief is certainly, that I think it's very clear. But again, that it's very clear that there would be an advantage. But we keep talking about AFP modernization as a background, no, to this to the EDCA, that it is part of that. And so I would like to see where in fact is that help going to be, how that help, or in terms of modernization, is going to be given to the Philippines beyond training, joint exercises, or so that we synchronize our procedures and things like that.
Mr. Senator, the EDCA also, as mentioned, prioritizes maritime security and maritime domain awareness. And with the timely prepositioning of U.S. equipment, though, as we have mentioned in the opening statement, the Philippine Department of National Defense and the AFP prioritizes its own capability upgrade program. There is a recognition that in the short term, there are gaps in our capabilities. And with the consented activities, not only through joint training exercises, but joint activities conducted by the Armed Forces of the Philippines with the U.S. forces, these short-term capability gaps with respect to maritime security and maritime domain awareness will be addressed.
But you are saying that these capabilities will be exercised by the Americans because they will have propositioned their equipment and facilities, and therefore having the use of that equipment and facilities, we will then increase our maritime security because the Americans are watching, not the Filipinos. That has not increased our capability. That has increased maybe the capability of the joint AFP and United States Armed Forces in terms of monitoring activity in our seas. But it does not increase our capability as a military entity, as the AFP. Well, at least maybe I don't understand how it will exactly work.
The protocol for activities to be implemented under EDCA would be joint, and we recognize that these operations must be joint based on legal requirements. As mentioned by Ambassador Iparraguirre, it is also very important that in pursuit of the AFP Modernization program, capacity build-up or skills build-up by the AFP would coincide with the procurement of modern defense equipment, thus expediting the capability of our AFP uniformed men and personnel for operating this modern defense equipment.
Well, I think we can just agree that whatever will be the provision of additional equipment is not included in the EDCA. Maybe it's in some other, maybe it will come up in some other annex. But as the EDCA is, yan lang naman ang, this is the only document that we can base all of these questions on kasi.
Mr. Senator?
So we will just have to wait, I think, for the annexes, or if it will come out in the annexes. Yes, Ambassador Malaya.
Yeah, I just would like to add that the programs that you mentioned, the FMF, FMS, excess defense articles, those are continuing. And with EDCA, I think they would even dramatically increase.
In what way would they dramatically increase, Ambassador?
Well, we just seen the two cutters, and I think they are looking at additional C-130s, but probably Undersecretary Batino. It's not here, sir.
But it will be in some annex somewhere at some point.
Maybe not here, sir. Maybe in other interaction.
So also, we can cite... But Ambassador, on the basis of this agreement that has been signed, there is no such talk of exchange or provision or credit or military sales.
EDCA is merely a framework agreement. It does not deal with operational details.
When do we get the specifics? Because we keep hearing about the recognition of the advantages of repositioning, the recognition of this, that, and the other thing, that it is part, but walang laman. When will this be determined?
Well, sir, for the panel, we are happy that we were able to conclude the agreement in a timely manner, and I guess the Department of National Defense, together with DFA and other concerned agencies, are taking it one at a time so that we can have an implementation of the agreement which is, well thought of, rigorously planned.
That's why it is being criticized as minadali lang para sa bisita ni Obama. That's why people look at the lack of detail, the lack of precise conditions and provisions. It is being speculated that the reason it is so general and so non-specific, and that there are still so many questions, is because it was a PR effort exactly for the visit of President Obama.
Not that I'm defending them. Just to be fair,
I don't actually.
2 years now. You've been doing it for 2 years. Yeah.
Well, that's why when it hadn't maybe again it was been worked on for 2 years, and yet we still have a fairly general. And yun na nga, I'm not making that criticism. I'm just making that point that has been said. That hindi ang problema kasi it's so non-specific. It is here, you are quoting back to me the recognition of both parties. That recognition is fine, but what does it mean? What does it mean in terms of actual operational, joint operations, in terms of equipment, in terms of what exactly does it all mean? And the vagueness with which the language is written just leaves it open to so many questions, and that's why, as I said, since wala naman talaga dito, hindi naman cannot squeeze blood from a stone, we will just have to wait for the annexes to come.
Actually, first of all, I agree that it's vague and very general because it is a framework agreement. And this is supposed to be an implementing mechanism of the MDT of 1951. In a way, I would like to look at the bright side that they agreed that the Defense Committee Chairman and the members of the committee of both houses will be furnished of the operational details and implementing guidelines, which will be done by the Mutual Defense Board. So we will have a hand in perhaps analyzing, studying, understanding, and making our comments on the implementation of the so-called broad framework agreement. So it would have been worse, I think, if they had entered into agreement, which we are against, and they will not bring it to the Senate for concurrence. Now, it may seem vague, it may seem like a policy framework, but you agree that you will consult with the higher ranking officials of the executive and with the relevant committees of both houses. Is that
Madam
clear?
Chairman, do not misinterpret me. I have complete faith in our panel, and that they will work. They will do their best to secure the interests of the Republic of the Philippines. Of that, I have no doubt whatsoever. Many of you are known to me, and I know that you have a long history of service to the country. So that is not the question. It's just that these questions are being asked, and for us, we need to know as much as we can, so that we can make a determination for our own purposes, an assessment as to what how good an agreement we have come to. Anyway, to get to my next point, since we were talking about material and prepositioning, there's the literally radioactive paragraph of Article 4. The preposition materials shall not include nuclear weapons. This is a standard, I think this is a standard condition. But how do we make sure that they do not include nuclear weapons? Because the policy of the United States military is to neither confirm nor deny the presence of military weapons on their vessels, on their aircraft, in their bases. That is the experience that we had before during the Vietnam War, during the when Subic and Clark were still being used. So, paano natin maititiyak na talagang walang nuclear weapon dun sa kanilang preposition material? Meron ba tayong na walang nakalagay dito na mag-inspection tayo? It doesn't say anything like that. So, how do we assess for ourselves? Pag sinabi natin, sinabi natin sa American military, can you assure us that there are no nuclear weapons within the material that you have prepositioned? Or there any nuclear material? Actually, it's more than weapons. It's all kinds of nuclear material. And they say we neither confirm nor deny. What do we do then?
Mr. Senator, if I may, we have a current procedure with respect to the entry of foreign military vessel or aircraft, and any country which wishes to send such aircraft or vessel are supposed to make a request for clearance through a diplomatic note. Then the DFA would consult the Department of National Defense, and if that request is to be granted, the note verbal would specify the conditions for the entry, and it is indicated there that there should be no weapons of mass destruction to be brought by the vessel into Philippine territorial waters or to be aboard the aircraft. And we also recall that in 1991, the then U.S. President George Bush stated that under normal circumstances, U.S. ships, submarines, and land-based naval aircraft will not carry tactical nuclear weapons. Also, we can notice that in the Balikatan and other military exercises that we conduct with the United States, these exercises do not involve nuclear weapons, chemical weapons, or biological weapons. All the weapons used are merely conventional. In fact, in addition to having a reference that there should be no entry of nuclear weapons into Philippine territory, the EDCA goes even further, because in the preamble, the EDCA reaffirms the respective obligations of the Philippines as well as the U.S. under the Convention on the Prohibition of the Development, Production, Stockpiling, and Use of Chemical Weapons, and also the Counterpart Agreement on the Biological and Toxin Weapons. So I think this, in fact, is a distinct feature in our EDCA if this, when compared with the other access agreements that the United States has with about 8 or so countries. Thank you.
Yeah, but again, to return to the question, is there any way for us to verify? Okay, the Americans will tell us there are no nuclear weapons of any kind, there are no weapons of mass destruction of any kind. Can we verify? Will we be allowed to verify whether or not that is the case?
There is a provision under EDCA, Your Honor, that provides that the Philippine Designated Authority under Article 3, Number 5, and its authorized representatives shall have access to the entire area of the agreed location. This would enable the AFP...
I'm sorry, Article 3, Paragraph
5.
5.
Number 5, sir.
The entire area.
It emphasizes that the DND, as the Philippine Designated Authority and its authorized representatives, shall have access to the entire area of the agreed location, which, aside from addressing the issue of exclusivity, which we think was sufficiently addressed under this EDCA, also enables the Philippine authorities to inspect the agreed locations shared with the U.S. forces.
So, such access shall be provided promptly, consistent with operational safety and security requirements, in accordance with agreed procedures developed by the parties. What are these agreed procedures? Yan na naman, wala pa.
Wala pa po.
But, so, bantayan nyo yan para medyo matibay-tibay yung ating verification.
Yes, sir.
I'd like to recognize Senator Sergio Osmeña. Welcome him to the committee. Serge, you have the floor.
Thank you, Madam Chair. Good afternoon to everybody. Almost good afternoon. Curious lang po ako kasi hindi ninyo dinaan ito sa Senado, no? It seemed to me to be a new treaty, and yet it was conveniently slipped in as an extension of the existing visiting forces agreement and the mutual defense treaty. Where in the visiting forces agreement are the Americans allowed to have facilities?
Your Honor, the premise...
We have a copy. Would you like to submit to the committee a copy of the following, now, so that for subsequent hearings we will be able to have a more accurate base for our questions? The VFA of 1998, the Mutual Logistics Support Agreement signed in 2007, which is another addendum to the VFA. Of course, the 1951 Mutual Defense Treaty, the establishment of the Mutual Defense Board in 1958, and the establishment of the Security Engagement Board of 2006. Pwede? All right. Now, of course, the Senate was sidelined here, so we'd like to know, the main signatory was the Secretary of Defense, General Gasmin. Where is he?
we were made to understand that the panel could panel.
All right.
Could,
Madam Chair, would the committee invite Secretary Gasmin and Secretary of Foreign Affairs Albert Del Rosario to the subsequent hearing?
next hearing, please.
All right. Now, explain to us how this thing became pregnant with so many addendums. You have the Mutual Defense Treaty, and they used that to sign the Visiting Forces Agreement in 1998, and then the Mutual Logistics Support Agreement, which was not passed by the Senate or concurred in by the Senate, and now this. Justify that this is not a new treaty.
Thank you, Senator. The authority given to the negotiating panel is to limit the EDCA within to be an implementing agreement of the Mutual Defense Treaty and the Visiting Forces Agreement. The Mutual Defense Treaty provides in Article 4 that both the Philippines and the U.S. would defend each other in case of external armed attack. But another significant provision in the Mutual Defense Treaty is Article 2 of the same, which provides that the parties through mutual aid and self-help will maintain and develop their individual and collective capacity to resist armed attack. And it is...
You're not answering my question. What does it say basis? Or facilities?
We believe that there will be no basis, Your Honor. The structures to be built under the EDCA would be in consonance with the policy established under the Visiting Forces Agreement that U.S. forces, when allowed by the Philippine government and for activities approved by the Philippine government, can visit the Philippine territory. It is in this light that related construction activities for these temporary visits by the U.S. we believe could be justified.
Okay, that leads to an interesting question. What is your definition of permanent?
In the EDCA,
now, what is your definition of permanent? Never mind what EDCA. EDCA just uses permanent. What is your definition of permanent? Not to establish permanent military presence or base. What is your definition of permanent?
It was the understanding of both panels that the presence of U.S. forces in an agreed location will be rotational, that it will be temporary. Meaning
in other words,
that U.S.
permanence refers to the personnel.
Yes.
Not to the facilities.
Yes, Your Honor.
All right. How long were the Americans at Clark?
More than 40 years, Your Honor.
No, more than 40 years. That was Fort Stotzenburg, and that was established about 1902. All right? Can you tell me any American soldier that stayed there from 1902 until 1992 when they left?
We believe that there won't be any U.S. soldiers.
That's right. So in other words, permanence does not refer to personnel. Personnels are always rotated.
It was agreed, Your Honor, that the presence of U.S. forces will not be permanent in an agreed location. That
no, forget the agreed location first. Will not be permanent.
Yes, yes, Your Honor.
Anywhere.
Yes.
All right, and you're saying that the soldier will not stay there except for a temporary period of time.
And even U.S. forces.
U.S. forces, yes. And you can't name a single soldier that has stayed in any American base around the world permanently. There's none.
Yes, Your Honor. They may
They're
be
all
not.
rotational.
What we
As a matter
envision.
of fact, you only serve the military for about 20 years and then you can retire. So, by your definition, that's not permanent.
What we envision here, Mr. Senator, is that for the activities, they will be temporary, and therefore, in an agreed
You
location.
did not mention activity. You said soldier.
Yes. That at one point, for any agreed location, the presence of U.S. military forces, or there will be
Will only be temporary.
an absence of U.S. military forces, even for the agreed locations, Your
Okay,
Honor.
so one day absent na yun. Tapos babalik, papasok yung bago. In other words, you're dividing it so finely in order to get past the meaning of the word permanent.
What we can explain right now, Mr. Senator, is that the direction of the DND and AFP is to have significant gaps in the presence of U.S. Militaries, and this could be controlled by
To get past the law.
Philippine government.
To get past the law. If I have a facility and I build something like hangars or barracks or whatnot, and I will empty it 1 month in the year, I may now claim that my presence there is not permanent. That's what you're saying.
At least the direction of the department is to have significant gaps, Your Honor, and
Okay,
this will have to be
define
discussed.
significant.
This could be discussed in the operational level,
No,
Mr. Senator.
you either know what significant is or not. So what do you mean by significant when you say significant gaps? Baka 3 hours significant na sa inyo.
Hindi po naman, Mr.
That's
Senator.
why,
we-
define it for us. What do you mean by the word significant?
Well,
Within the context of the phrase significant gaps.
well, the department can provide these definitions in future circulars, Your Honor.
No, I'm not
That would
asking you
control-
because you already signed this. So therefore, you must have had, or you must have put meaning into the phrases that you now use. So since you use the word significant gaps, I'd like you to define significant for the Senate committee.
Initial talks, at least, and informal talks with
Informal.
Yes, Your Honor. There would also
The
be
key to the word, to the meaning or definition of the word permanent is now defined by you as to mean significant gaps. So I'm asking you to define significant, and you cannot define significant.
We believe that this could be defined later on in other implementing
Next year.
regulations.
Because when you sign something, you better know the meaning. And so when you put the word, no, will not establish a permanent military presence or base. Now, I'm not talking about presence now, I'm talking about the base. When you build something, that's permanent. If it's exclusively for the use of a foreign force, that becomes their base, correct? And earlier I heard, because I've been monitoring the hearing since it started, that the Americans will be building permanent facilities. As a matter of fact, you went further to say that any permanent structure will be left and will become the property of the Republic of the Philippines. Am I correct?
Yes, Your Honor.
Okay.
Please clarify the statement of Senator Osmeña about the exclusive use of the American forces. In my understanding, the Philippine troops have full access to every structure that will be set up by the Americans within the Philippine bases. Can you clarify that, please?
Yes, Your Honor. During the times that the U.S. Forces would be absent in agreed locations, and also while they're here, if sharing of the facilities could be implemented with the U.S. Forces. In fact, this is been going on also for the activities implemented under the Visiting Forces Agreement. Small-scale constructions have already been implemented, such as barracks and other training facilities. And when they're not here, Your Honor, these improvements are used also by the AFP.
Undersecretary Batino, you and I know that you're not going to be allowed to look into certain facilities they will be building in the future.
Senator Sir,
even
I'm sorry to
excuse me.
Yeah.
Even Senator Marcos asked earlier on the inspection of nuclear weapons. I think essentially the policy is don't look, don't ask, and don't tell. Hindi naman pwede i-offload. May I just continue, please? You know, if you're a nuclear sub, you're not going to offload your tactical or strategic missiles in some small island before you come into Subic to do some, not refueling because they don't need to refuel, but resupply, rest and resupply activities. And those are the realities of the situation. We won't be able to check. And personally, I'm in favor of what you signed with the United States. I just want to know why it was not passed through the Senate for its concurrence so that we could examine. But I believe that we have a joint responsibility to maintain the peace in this part of the world. And I'm not looking for rental, I'm not looking for assistance. This is our share in maintaining peace in this part of the world. Except that sometimes it becomes so one-sided that the visitors become permanent and the permanent residents become visitors. All right, but let me, Mary.
Has he answered your question on the exclusive use? Because I believe that you should.
I'm on the word permanent. Did you want to change the subject?
I think you should read into the record Article 3, number 5, about the question of Senator Osmeña on the exclusive use, because there is no exclusive use, and there should be access of the Philippine designated authorities, just to quench.
Yes, but I already responded to that. I said that
Article 4, paragraph 3 also says that the
what we
material should be exclusive use of the United States forces.
Explain those two contradictory.
The preposition material is recognized to still belong under U.S. ownership. That is, we believe, a reasonable provision
recognizing. I think that's the way it should be.
However, the mutual benefit is something that is a concept that is underpinned in this EDCA, as mentioned in the preceding paragraph that mentions that there is a recognition of the benefits that such prepositioning should have for HADR. And through the years, Honorable Committee, the cooperation between the AFP and the U.S. with respect to HADR, while they're here, have been proven to be strong and have been proven to be available when in times of crisis.
All right. Okay. There is another point I'd like to raise with you. You still haven't answered the question permanent, but we'll let you do your research. There's a phrase here, as mutually determined by both parties. What will be determined? And I find that in line, wait a minute. On page 2, authorizing access to agreed locations in the territory of the Philippines by U.S. forces on a rotational basis as mutually determined by the parties.
The meaning of the phrase as mutually determined by the parties would reflect the existing bilateral mechanisms conducted between the U.S. Between the AFP and the U.S. Armed Forces, the activities that would determine the rotational presence of the U.S. would still have to be determined regularly by the AFP and the U.S. Pacific Command through the Mutual Defense Board and the Security Engagement Board. At this, maybe it would also be worthy to mention, Your Honor, that for the construction and prepositioning activities that would be implemented under this EDCA, there is specific reference to the role to be played by the Mutual Defense Board and the Security Engagement Board, thus emphasizing the role that the AFP would be playing in determining and in consenting to any activity that would be implemented under EDCA.
Okay, yeah, that's the good side. But the other side is that this is expansive. They could eventually have 100 bases because it was mutually agreed to. Correct? Or 100 facilities.
That possibility is there, Mr. Senator, but may I just also explain that for the defense establishment, at least, the recommendation is to limit the number of bases to a manageable few that would already sufficiently address
define manageable
the concerns.
few.
Sir, that will have to be
10?
Discussed and studied.
20? 30? 40?
At least now, Mr.
50?
Senator, we're just talking about a possible, as we had mentioned in media, 3 to 5.
3 to 5. Ay, hindi ako naniniwala dyan. You know why? Because every facility that they set up becomes a base. Even an antenna on top of the mountain becomes a base. Becomes a facility. You know how many bases did the Americans have before they left the Philippines in 1992? Something like 40, 50.
Your Honor, at least the practice now when it comes to at least one example of a facility is a radar station.
That's right. That's a base also. That was a base under the old arrangement.
We have our agreements with the U.S. for grants for radar stations, but these radar stations are transferred to Philippine ownership and in fact manned by the AFP.
Yeah,
so
that's what I'm saying. There's practically no limit to this. It's so open and expansive that if anything is required, sige, idagdag mo.
we believe, however, Your Honor, under that setup, that will no longer be a foreign facility as the grant of the equipment would already be absolute and the usage of the equipment would
Believe me,
already
you will
be...
not be able to touch the radar facilities. But that's okay. I don't care about that. I just want the definitions down. But if it's extremely sensitive and it has to do with controlling the aircraft, you won't be able to come close to that facility. Now, what about the cleanup of toxic waste? The U.S. has a law which is known as the CERCLA, the Comprehensive Environmental Something and Cleanup Act of 1980. It's known as the Superfund. Would that apply now in areas where U.S. facilities will be set up? Not that we're exactly careful about not harming our own environment, but during the VFA debates, I took objection to their refusal to clean up the toxic and hazardous waste they left behind in Subic and in Clark, especially in Subic and in Clark, which were huge. And the Philippine government never held their feet to the fire. And here we have another arrangement And you seem to have a rather weak protective clause on toxic waste. Now, remember, there's a huge amount of toxic and hazardous waste that is released when you've got refueling, bunkering. Naku, natatapon lahat ito sa sa lupa. Now, to give you a basis for our findings, it was the U.S. Congress General Accounting Office that reported that there were significant, that was the word they used at that time because they had not done a thorough inspection and scoping, significant amount of toxic and hazardous waste in Subic and in Clark. So I didn't say that. They said it. And yet they did not implement their own law outside the United States. In other words, that law only applies to this illegal or illegitimate disposal of toxic and hazardous waste within the continental United States and its islands like Hawaii and Guam, but not to areas where they have even U.S. bases. No? So when they deported Clark and Subic, they did not bother to clean up the toxic and hazardous waste, and several of our children died because they contracted leukemia, other diseases. Many were born with heart problems. And I just like to make sure that there is a cleanup clause. You did not include a cleanup clause. Yes.
Thank you, Your Honor.
And it would not have harmed them to include a cleanup clause.
Thank you, Your Honor. You're absolutely right, Your Honor, that the CERCLA does not have extraterritorial application, and that the remediation funds appropriated by the U.S. Congress are only meant to remedy environmental contamination in the U.S. But here in the EDCA, we have negotiated a strong provision on environment, and now in any of our previous security agreements with the U.S. that we have a provision on environment, human health, and safety protection.
It's strong to you. Let me interrupt you, Madam Ambassador, if you will forgive me. You are using a sales gimmick by saying it is stronger than any other thing we have signed. Well, we've always signed weak agreements, weak as far as our side is concerned. Now, are you referring to Article 9, Environmental, Human Health, and Safety?
Yes, Your Honor.
All right. I would like to refer you to paragraph 3, which is one sentence. United States forces shall not intentionally release. Now, there's that word intentionally. If they unintentionally release, pwede pala. Ha? Ba't ganun? You know, those guys are very smart. So they say it was an accident, so it was not intentional.
Yes.
Release any hazardous materials or hazardous waste owned by it, and if a spill occurs, shall expeditiously take action in order to contain and address environmental contamination resulting from the spill. It says contain. Now, when you're doing cleanup, there's such a thing as containment and there's such a thing as removal. It doesn't say removal. And it does not include any cleanup costs or remediation costs. That's a single sentence. And what bothers me is the word intentionally. And what if they unintentionally release it? Does that forgive them from this clause?
Thank you, Your Honor. If I may explain, Your Honor, the focus of this provision on protection of environment, human health, and safety is prevention. It's adoption of a preventative approach. But But if a spill occurs, the concept which is being applied in U.S. laws, which says clean as you go, would be applied. That means they would right away contain and address. The word address is very broad, Mr. Senator. We feel that to some extent it could also cover negotiations on remediation.
You feel that to some extent. Boy, that's as vague as you can get. We feel that to some extent. I want something specific.
Yes.
They're going to clean it up and they're going to take it out of the ground and destroy it.
Yes, Your Honor.
Not what we feel is what we think it is.
Maybe, Your Honor, I did not explain myself clearly. I have to apologize for that. Yes, because we are aware that the U.S., as I mentioned earlier, CERCLA has no extraterritorial application, and there are no remediation funds available for remediation outside of U.S. territory. But in some cases, as in the case of their bases in Japan and Korea, there have been negotiations. And you have to negotiate, I forgot the term now, it's a joint environmental assessment agreement. And here, there's a possibility of negotiating.
There's a possibility
of negotiating assistance for remediation funds. That's why here in this agreement, Your Honor, the focus is really on prevention. The focus is on containment, and when a spill occurs, to address it right away, because it would be more expensive if the spill has already sunk to the ground or under the pipes.
We know that you don't have to lecture.
Yes, Mr.
But
yes,
the
Your
thing
Honor.
is, well, the focus should always be on prevention because, you know, the saying, an ounce of prevention. Still, we want to see the pound of cure guaranteed. We're not saying go ahead and spill whatever you want as long as you clean it up. No. You will do everything in your power to make sure that the spill does not happen. But it will happen in these types of activities. Like you've got refueling, you've got bunkering, sus Maria. Sigurado yan, no? So we want them to be a little bit more careful if we say you're going to pay a lot, depending upon the amount of toxic and hazardous waste that you spill. So
yes.
that protects our people, because sometimes many of these bases especially are going to be out in the boonies, in the boondocks, and they're just going to be left. Pag alis ng mga foreign visitors natin, wala na, bahala na kayo sa sarili ninyo, no?
Yes.
Which is not what we want to happen.
Yes, Your Honor. Earlier, you also mentioned about removal of hazardous wastes. This provision in the EDCA is supplemented actually by a bilateral agreement that we have with the United States, concluded in 2001. And this is the Philippines-United States Agreement concerning the transboundary movement of hazardous wastes from the Philippines to the United States, which provides for environmentally sound management of such transfer of transboundary movement of hazardous waste in accordance with the Basel Convention.
Yes, the Basel Convention is good, but it is honored more in the breach than in practice. And that agreement should have been part of the basis agreement, because especially for people like us, we don't know every agreement that has been signed under the sun, and we want to make sure that we cross our I's and cross our T's and dot our I's when we get into something like this. Now let me move to another question I have. In the Bangsamoro, if we pass the Bangsamoro law, and the United States would like to establish some facilities there, do they sign with the Bangsamoro or with the Republic of the Philippines? And does this cover any base then that would be established in Bangsamoro territory?
If I may, Mr. Senator, the matter of defense and security is a reserved right to the central government. So the operation of AFP camps within the Bangsamoro will still be within the purview of the national government.
All right, so the Bangsamoro may not sign and will not be able to sign under the proposed law because we have not passed the law. But under the proposed agreement, the Bangsamoro agreement, hindi sila makakapag-sign ng foreign facilities, foreign military facilities. They may not commit.
Under the present text, defense and security is a function for the national government, still reserved for the national government.
All right.
Your Honor.
Now, what about other foreign facilities? Suppose the British come here and ask us, can we also have facilities? Will they be allowed under existing laws?
We believe that based on the Constitution, there being no mutual defense treaty with those countries, then there can be no basis for the implementation of a similar EDCA.
Now, a mutual defense treaty can easily be drawn up and signed also with the UK, no? But that would be subject to the concurrence of Senate. So that will have to pass by the Senate, and it cannot, hindi pwede palusutin dito sa yung example na ginawa ng ng administrasyon dito, because I still find fault that this particular agreement is not considered a new treaty. See, it is expansive. So in-expand niyo yung BFA, in-expand sa Mutual Logistics Support Agreement, in-expand dito, and you can expand to 100 bases, and it will still not be subjected to the concurrence of the Senate, and I think that's unconstitutional. No? Of course, there's a case that's been brought in the Supreme Court, so let's see. But I think that it cannot be like a rubber band. Na may maliit na butas, ayun, wala na. Dinaan na lahat sa butas na yun.
Perhaps they can also answer the question with regards to the Australian Visiting Forces Agreement, because the Senate recently ratified that agreement. Based on a question of Senator Surge, does it mean that based on the VFA with Australia, can they also have an EDCA and access to Philippine bases on agreed locations with the Australians?
Do we have a copy of that? Would you like also to submit a copy of the
Maybe an answer to that.
Australian VFA?
Can we have an EDCA with Australia, because it will be based on the VFA of with Australia?
My opinion is that it cannot be undertaken with Australia based on the existing legal framework that we have with Australia. What defines the relationship between the Philippines and U.S. militaries is still the Mutual Defense Treaty. In fact, in one case, the Supreme Court ruled that the Visiting Force Agreement, in the aspect of mutual defense capability building, is just an implementing agreement of the Mutual Defense Treaty. As mentioned, aside from Article 4, which is the more prominent article of Mutual Defense Treaty, which is the obligation of the parties to defend each other in case of external armed attack, there is a provision that emphasizes the preparatory stages, the enabling, the increasing the mutual and individual collective capacity of both the AFP and the U.S. forces to resist armed attack. The joint training exercises, as facilitated by the Visiting Forces Agreement, did just that. We increase our interoperability, we increase our mutual and collective capacity for mutual defense. And EDCA, we believe, also complies with that objective of Article 2 of the Mutual Defense Treaty. As the VFA already approved the policy of allowing the temporary presence of U.S. Forces here in the Philippines, provided that these activities are approved by the Philippine government. We believe that the possible prepositioning and construction of related equipment that would be related to the visiting forces could also be allowed under the existing legal framework.
May we know what existing bilateral defense agreement we have with China? I know that we have a limited one, but it's not really being pursued or implemented. Thank you.
We presently have an MOU on defense cooperation. This will in
Defense of what? The Spratlys?
This will just enable the officials of the defense departments to meet regularly, to also enable exchange of military delegations, and to provide educational and training opportunities. We must, probably it's worthy to mention now that the defense cooperation is really built through time. And with the U.S., our defense relationship had started way back and is anchored on the Mutual Defense Treaty. Through the years, based on the objectives set forth and the policies set forth under the Mutual Defense Treaty, other agreements had been put in place, including the Visiting Force Agreement, which was already also concurred in by the Senate. And these policies are those policies that are just being implemented through EDCA. Preparation for mutual defense and the acceptance or the approval of temporary U.S. presence provided activities are consented upon by the Philippine government.
Yeah, that's why we will have a permanent disagreement. You always call it temporary U.S. presence, and it's really a permanent U.S. presence, which I'm not against, like I said. But let's call a spade, no? I have another question. You granted the U.S. government a telecoms franchise, something which only Philippine Congress can grant. A telecommunications, practically a telecommunications franchise. Yeah.
Mr. Senator,
Yes.
if we can clarify.
That's Article 7.
Yes.
Utilities
What
and
is talked
communication.
about here is the use and operation of radio frequency and spectrum by the U.S. forces for their internal use.
It doesn't matter what for. The moment they use our spectrum, they're required to obtain a congressional franchise, particularly when it's an exclusive use.
Our reading of our relevant legislation, Your Honor, is that a franchise would be needed if there would be such operation for commercial purposes.
No, even
or
before
operation of a public utility.
Even before we had a private, we just a single sideband, we had to get congressional franchise. Now I don't know if the NTC can grant that, but you know,
Yeah.
the ability to operate, the full ability. You see the word full ability to operate a telecommunications system, which means they're going to ask for exclusive use on a spectrum. I mean, they have very sophisticated equipment. It's not only, we're not going to limit them to 1 megahertz or 2 megahertz. They're going to need a whole range from low frequency for their submarines to to high frequency, to very high frequency, to ultra high frequency. And I'm not against that. I'm just saying you may have violated the law, or I think Commonwealth Act 146, if my memory serves me right, the Telecommunications Act that was passed during the Commonwealth, where you're required to get a congressional franchise if you want exclusive use. Meralco uses, but they have a franchise because they need that for their SCADA and for their lines, their distribution lines. Napocor has, and it's been transferred to NGCP, the Transco. So anybody that has exclusive use needs a franchise. It doesn't have to be for commercial purposes. You don't have to make money or not. If you have exclusive use, you must get a franchise. So will you look into that and answer that in the next...
Yes, Mr. Senator. In fact, we consulted the National Telecommunications Commission, and it was told to us and also affirmed by the AFP that the NTC gives a bundle of frequencies to
That's
the
right.
Armed Forces
They
of the
assign.
Philippines.
Yes.
So the Armed Forces of the Philippines
So they're going to
will
use the armed
designate-
forces frequencies.
That is right. So if you'd notice, Mr. Senator, it is indicated here that the right to use all necessary radio spectrum allocated for this purpose. So it would be the AFP who would be giving this, sharing what they have. And it would be
Where
up
does
to
it say
the,
armed forces of the Philippines? Where?
both sides, when we were
Where
this-
does it say, which line does it say, mention
allocated for this purpose.
allocated for the
yes.
armed forces of the Philippines?
It's not in EDCA, Your Honor.
So you're inventing something now?
No, fortunately not. It is also in Executive Order 546, Section 17. This is 1979. It states that telecommunications stations owned and operated by the AFP shall not be subject to the provisions of this EO, except that all such stations shall use frequencies as may be allowed assigned by the Commission. So, in short, by practice, the NTC gives AFP a bundle of frequencies, and the intent of that provision is for the AFP to share only a number of frequencies for the use of the U.S. military. And may I also...
In other words, every time the United States Armed Forces wishes to have a new frequency or part of a higher or lower spectrum, all they have to do is ask the AFP to apply for it and then come in and use it.
My understanding is that bundle of frequencies already allocated, so they will
No,
have...
don't kid yourself. These things change with technology. They open up higher and higher frequencies. That technology that was too expensive to use before. No, even your GSM now is ultra high frequency, and 30, 40 years ago, they didn't have something that they could miniaturize in order to make it commercially feasible to sell as cell phones. No, nobody thought of a cell phone 40 years ago. There were walkie-talkies, but it was on a lower bandwidth. Anyway, we just want to make sure that you explain this to us in a memorandum, please, and let you have to backstop our concern that a congressional franchise should have been given. Of course, that's the way around it, no? So, yeah, assigns armed forces to the Philippines, and then it is lent temporarily to the armed forces of the United States.
We will do, Mr. Senator. Thank you.
That's all I... Oops. Had a disappearing chairman there. Okay. That's good. Let me go on then to more questions. how would any resolution of disputes be decided under this? Because you've said, hindi kami pupunta sa husgado, hindi kami pupunta sa International Court of Justice or International Criminal Court. So it will be like China, it has to be bilateral. Itinala namin yung China sa International Court sa UNCLOS.
We recognize the alliance and the strong partnership with the U.S. Built through the years, and that in recognition of the long years of cooperation, it was agreed that disputes with respect to the implementation must be resolved first by the parties themselves.
First. Secondly,
must be resolved by the parties themselves, sir.
So we have agreed to do with America what we refuse to do with China. In other words, resolve it by bilateral talks, through bilateral talks. Just say yes.
Yes, because this is an implementation of an agreement, Your Honor.
Okay. This is a left field question. Ba't hindi ninyo pinasok dito that the United States hereby recognizes the right of the Philippines under the UNCLOS to its 200-mile exclusive economic zone? I'm just asking. Sabi ko left field
Yes.
kasi.
We believe, Your Honor, that said topic could be outside of the purview of the Defense Cooperation Agreement, as this
it could be part of the Mutual Defense Treaty because the territory of the Philippines would be under attack. Diba?
The authority to the negotiating panel is to negotiate an agreement that will just implement the policies already laid out in the treaties executed between the Philippines and the U.S. And any amendment of these policies is outside, I think, the authority and the purview of this negotiating panel.
Now, in the Mutual Defense Treaty, I remember a phrase that said the territory of the United States and islands in the Pacific. Can you point out to us which islands in the Pacific the United States meant? Under the MDT, there is mention of islands in the Pacific. Does it include American Samoa, Palau at the time, the Marshall Islands, Guam, Okinawa, Wake? Because I think that we committed ourselves to help them if those islands were attacked, because those were U.S. trust territories. They were not part of the United States, but they were under, I think, United Nations mandate, handed it to the Americans to take care of. And up to this day, I think their foreign policy and their defense policy is determined by the United States of America. So these are islands that we don't think of, but the Americans could consider this U.S. territory. Ambassador Malaya, are you familiar with this? Were any of you ever assigned to the United Nations? May experience kayo sa United Nations? Wala. Yes or no?
Not in the UN, New York, Mr. Senator. I'm assigned to as permanent representative to the United Nations in Vienna.
United Nations of India?
In Vienna, Austria po.
Oh, in Vienna. Well, what particular office do they have there?
Yes, there are several UN and other international organizations, including the International Atomic Energy Agency, the UN Office on Drugs and Crime, UN Office on Industrial Development Organization, Comprehensive Nuclear Test Ban Treaty.
Oh.
Opo.
All right.
Among others. Po.
Can you check what is the status of areas like American Samoa and Palau, the Marshall Islands, Wake, Guam, Okinawa, Saipan. These are all under U.S. jurisdictions, and U.S. laws are enforced, particularly even on islands like Saipan and Guam. So, do we have to become the defense of the United States in case those are attacked? We can send some bangkas. Malapit lang naman yun eh. But see, I think we committed to all their possessions to cooperate in the defense of their possessions. So I was wondering to what extent they are committed to come to our defense in our territorial waters.
With respect to your query, Your Honor, may we be allowed to present a memorandum to answer
please.
it? Query?
Yes, that will be fine. Again, I would like to reiterate, I'm in favor of the United States has given us 70 years of stability since the World War, and they've always been very benign. Of course, when we come to agreements like this, it tends to be one-sided in their favor because we don't want to stand up for our few rights. But in general, I'm in favor of cooperation with America, and I think that I will not even ask questions about rent or rent or compensation, because that would be insulting. This is our contribution to the stability of our own region, which America has also seen fit to take responsibility for. I also believe that the battle is not essentially one of national pride for China, not essentially that, or resources in the fishing resources or resources beneath the sea such as oil and gas. But I think one of the main long-term concerns of China would be control of those straits which the U.S. forces were here for, in Subic and in Clark particularly, the 7th Fleet and the 13th Air Force, which is control of the choke points leading to the South China Sea and the West Philippine Sea, which are the Straits of Malacca, the Upper Sunda Straits, and the Lombok Straits. Ayan ang choke point. That is what China also would like to control, because the trade from Europe will come through those straits before they reach even the South China Sea. So the South China Sea is just a big swimming pool, but the pipes that lead to the swimming pool that supply the materials, the energy, the natural resources it imports from Africa and from Latin America will have to go through those three straits first. So I think that's the long-term intent of China. And it's exactly the same thing that the 7th Fleet was here for. It was to make sure that those straits would be kept open for international commerce and for military uses especially. So I'd like to thank you, Chair, Madam Chair, but I hope you can have a subsequent hearing with both Secretary Del Rosario and Secretary Gasmin as our resource persons.
I'll tell the chairman here, unless you'd like, he'll be away till end of May, unless we can have
That's okay. No, we can have it in June. Yeah. Thank you. And thank you, everybody.
Thank you, Senator Osmeña. May I ask about the environmental destruction aspect before we adjourn? Because in items 1 and 2 of Article 9, environment, health, and safety provide for the importance of environmental protection. And beyond guaranteeing that, and I quote, problems that may arise are dealt with immediately, the EDCA has no provision on compensation. unless I'm mistaken, so I want that corrected. Because I recall when I was defending the Australian SOVFA, a sponsor, and I looked for that provision, it has pertinent environmental and health protection provisions, and it clearly provides for the indemnification and compensation in instances of claims arising from environmental incidents from joint military exercises. In fact, if I may state the Australian SOVFA, it says in Article 8, Section 7, the government of the sending state commits to conduct, in coordination with the authorities of the receiving state, periodic environmental aspects of such combined training, and the government of the sending state shall promptly undertake to remedy contamination caused by the visiting force and its civilian component. And it further states that any environment damage to individual and or properties resulting from combined training exercises or other activities mutually approved by the parties will be subject to claims and compensation. That is insofar as a SOFA is concerned. I just want to know why these provisions were not included in the EDCA when the Senate, during the ratification of the SOFA, which I sponsored, highlighted the need for such provisions in future agreements. Unless I do not see it in the EDCA agreement, kindly cite to me the same agreement in EDCA which is in the Australian SOFA. Thank you. In short, it should be as strict as the Australian SOFA, and that's the reason why I concurred in it and even sponsored it. The EDCA now seems more vague in terms of the environmental cleanup aspect raised by Senator Osmeña.
Thank you, Your Honor, Madam Chair. Yes, the EDCA agreement does not provide for remediation costs. Of course, we were informed by the U.S. that it's not possible for them to agree to put it in this agreement because they do not have remediation funds that could be applied or used outside of U.S. territory. In fact, even up to now, their bases military bases in South Korea and Japan also have similar problems because the U.S. law, the CERCLA, does not have extraterritorial application. That's why we negotiated the best kind of provision that we can have on protection of environment, human health, and safety. And that is the provisions, as I mentioned earlier, the full respect for Philippine environmental laws, the application of environmental compliance standards that are more protective of Philippines, U.S., or applicable international standards. Madam Chair, the focus here really is on prevention. And
accidents cannot be avoided. So it's saying that, yes, we will respect your territory and will abide by all conventions. However, if there is an accident and we cannot avoid that, we don't have remedial funds allowed by the U.S. Congress, by our government, and you will have to take care of remedial measures and or compensation if such happens?
Madam Chair, there is a provision here in Article 9, Paragraph 3 of the Provision on Environment Protection, which says that if a spill occurs, then the U.S. forces would take immediate action to contain environmental contamination and address. And address is a very broad term, and there are possibilities, of course, of negotiations or discussions in the future of some remedy, not only to contain, but to address environmental contamination.
And so my understanding is it does not mean necessarily because they are not allowed to have a remedial fund outside of the United States that they will not address any accidental environmental damage wrought on our Philippine environment. They will source the funds elsewhere and do it legally. That's their responsibility. But they will address the concern and take responsibility for it. What was it about the SOFA that differs from that. Australia allows remedial funds outside of Australian territory. That's why we have a more stringent environmental provision in the SOFA. Is it because of the Australian laws? We have a better panel negotiating for SOFA.
Incidentally,
Kayo rin yun eh.
Madam Chair, I was a member of the negotiating panel on the visiting forces with Australia many years ago. And in fact, thank you very much for your sponsorship of on the concurrence of that
Kaibahan,
treaty.
bakit natin na-swing yun sa Australia, wala sa Amerika?
I think, Madam Chair, there are provisions here which are in fact more advantageous to us than the one with Australia. And principally, the line in Section 2, which says that the environmental compliance standards to be applied shall reflect the more protective of U.S., Philippine, or applicable international standards. So, if the international standard is more protective, then that is what is to be applied, and not necessarily the U.S. standard. We don't have a similar provision in the status of forces agreement with Australia. Of course, our initial instinct during the negotiations was to use the SOFA with Australia as our reference point. But, and it was one of those topics where we weren't moving for a long time. So, in the end, when this provision is in fact compared with the other access agreements of the United States, this looks so much better.
No, I just wanted to comment, Madam Ambassador, you were using the line that the the American negotiators said that CERCLA does not cover the Philippines. That's true, but that's irrelevant because they can always appropriate monies that will cover this sort of emergency. So to say, well, you know, we have an existing law, but it doesn't cover the Philippines, will BS. Tell them to go screw themselves. That doesn't help. No, put it on record. What is the name of the guys? I know they sent tough guys here to negotiate this. So, can you give me the names of the members of the U.S. panel that negotiated this?
It was led by Ambassador Eric John.
Who?
Eric John.
Spell that.
ERIC.
C-R-I...
ERIC, sir. Eric.
Yes, Eric.
John.
The family name.
It's John, yes, sir. The family name is John. John, sir.
Really?
Yes, sir.
Eric John. Okay. And who else?
Members of the Department of Defense, their General Joaquin Malavet. And
come on. You had there were several there. Do you have the list with you or not? If not, submit it, please.
We will submit it.
Yeah,
Your
okay.
Honor.
All right. Yeah. Well, don't be fooled. Those guys are really tough negotiators, and if they feel that you're not going to push, then they're going to have you over a barrel. In any case, thank you very much, Madam Chair. That's all I have for today, and I'll prepare questions for the next hearing.
Thank you. We thank Senator Osmeña for his very active participation. Of course, the chairman and the members of the panel. It's past lunchtime. We thank you for your patience. And the chairman will take over in the next hearing, hopefully with the presence of the Secretary of Defense and Foreign Affairs. Thank you.
Thank you.